gets us.
Thank you for today. Thank you for all the blessings that you give us. God, as we go into looking into all of our ordinance and our policies tonight, I just pray that you give us the wisdom and the judgment we need to make on what we need to keep, what we need to change, all for our population here in Damascus. It's in your holy name I pray. Amen.
Amen. All right, we have one objective tonight, and that's to go through our entire ordinance schedules. We need to get these prepared. Some of them are, as Bo will tell you, are obsolete. Some of them are just need some wording changed in them. Some our new ones are all okay, but some of these go way back, and I don't think have ever been looked at. So that's our job tonight, to get this done so that we can vote on this in our upcoming council meeting. We will need to, the way we're gonna go about this, and I've talked with Bo about it prior to the meeting, is we're gonna go by these one by one. It's gonna take us a while, but I think that's the only way we can do justice on getting this accomplished. So let's just go ahead and turn in your packet there, and we'll get started. I may not have the same packet as you guys, but I think so.
Yeah, it should be that so. That Title I is really all the stuff that the municipal league just added about how they do the code, how the justification, all the state law references. So really I don't know if y'all went through it, but I don't think there's anything we need to touch on in Title I. Our stuff starts really with Title II.
Right. One thing that we, and I don't know that this makes a difference, and you guys can chime in on it, but almost all of these have the city of Damascus, and I think we need to make sure that they change that to the town of Damascus. Wouldn't that be prudent for legal?
I would agree.
Precedent?
Yeah. I noticed that as well.
We'll make a note of that.
And if it grows out of town status, you can just say city council from there, so.
Yeah. Okay, page 1, designated and cited. I think that's pretty.
I think we're on page 8, aren't we?
Is it on page 8?
I mean, I think we,
Yeah, Title I.
I think we decided we
Okay,
don't
is
do
that all
that.
Title 1?
Yeah, I think
Title
Title
I
I is appropriate,
Yeah.
and there was,
Under the rules of construction, then that's under Title 1.
All the Title I is the stuff that the county
Municipal league.
we put in there for all, to make sure it's all nice and legal respect. Our stuff really starts with like page 8. That says Title II at the top of it.
One thing under the referendum petitions, that'd be on page 6, under 1.3602 publication. It says under there, the posting requirements. Do we not need to include about our social media and web pages instead of just?
This is what's required by law.
Yeah, I don't think we need to,
And
because we're doing it, I don't think we need to put it in there.
right, I think this is just kind of the minimum standard, so
minimum
to speak,
standard.
and so I think that's
Okay.
fine, and then you guys can enact
Go
further
through
ordinances
that.
or whatever else, or you can probably just by resolution and say that we want to use these methods to,
Okay.
handle
So
it.
I just had a question mark by it, so I wanted
Yeah.
to make sure. Okay, Title II. City classification.
I believe that is this technically not an incorporated town by definition? So I think that again is a city classification there.
Okay,
Second class city?
Yeah, I don't, now that may have been, again, I don't know when that was enacted. If that was done in 19, whatever year that all this was started, then that may explain that, it may,
1977?
that's what I saw, yeah. And
That's
so,
one day that's
If you look online, it shows us the second.
is it second class?
Second class.
Yeah, I've seen
Yeah.
that one.
Gotcha.
so should that not be under the classification?
Should we be a town though?
Well, we're
I
town
just
on the
don't want,
second page.
right, I want her to be consistency,
Yeah.
from one document or one section to the
On
next.
20801, we're the town of Damascus.
Right, I noticed that too. Again, there's like a,
And then we're the city of Damascus, the very next one.
We just identify how we want to.
Well, so does everybody else. So
Yeah.
I guess that's okay.
that's fair. I mean, there is a lot of, but that's kind of flexible, if you will.
Town,
But
city, I
at
don't
the
even know
same
what's the
time, I think
definition.
that, again, if you're going ahead and doing an overhaul, you just want consistency there. And
Right.
Brian, I'll rely on your information. If that's the classification, then, I think then it's fine, obviously, to leave it as is.
I
But
think I saw it on
it was on the municipal
the
league website.
second state or.
Oh,
I've
okay.
seen it, yeah, I've seen it
Okay.
on something too.
I kind of thought that, but again, if this was enacted,
It confused me because we don't meet that.
right.
We don't meet that,
Population, we're a town,
Right.
but if we're declared a city, then that's gonna change all kinds of
Yes.
election procedures.
That's right.
Yeah.
So we need to make sure we are
I think it
a
needs to
town.
stick with town.
Yeah.
Yes, because
in
otherwise
terms
it's
of-
gonna be some of y'all are elected one time and some of y'all are elected the second time.
Mhm.
That it's a totally different ballgame if we're second class city.
it's everything
Right.
across the board has
Right,
changed.
so we're a town, that's what we've been operating as, we need to make sure that gets clarified, that we're a town of
Okay.
Damascus and not a city of second class. If it's listed somewhere wrong, we need to,
Good to
whatever we
get
gotta
that
do to make it
addressed.
right.
So let's make a note on
I think
that.
that's a big,
Yeah, because otherwise it's elections, it's elections.
Need to make a note of clarification for town. Okay. 208, I don't think that has changed. Two 21201,
Yeah,
we
we have
don't,
to strike court clerk, because we don't have a court clerk anymore.
right, so we need to scratch that. Let me get clarification on this, Bo.
mhm.
By changing these, how do we go about doing, we're gonna have several changes throughout this whole thing.
I think the way to handle this is sort of a collective repeal, okay? Where we just identify everything that's gonna be repealed, okay? And do that through a new ordinance that says we're repealing all of these old ones, basically. And we'll identify them, by title or whatever, but we don't have to, regurgitate all the verbiage. I think the thing to do there, like I said, is as we go through this and there's some stuff like this one that we just completely strike,
Yeah.
then what we'll do is again, just do a collective repeal of all those. And then of course, if there's gonna be anything new enacted, we'll have to take those case by case, if you will. But, and I'll double check this, of course, but I believe procedurally, it's okay for you all to just enact an ordinance that effectively repeals everything that we purge, so to speak.
Okay. All right, so, chapter 220, under court clerk, that will be eliminated.
Two point two oh.
We're just doing
2.20
section. Yeah.
and 2.2002. Those will be eliminated. City court,
We've clearly changed
Yes.
location and time.
And we're not a mayor's court anymore.
That's correct. And so this provision probably can be stricken. Other than the establishment clause, I guess you'd say. We can amend this one, and the whole concept of true city courts is gone too. It's
Right.
all district court and underlying cities to that. So I don't know, since this was a reference to the mayor's court and the mayor levying fines and whatnot, I don't know that we need this section at all. I think it's antiquated in every way, yeah.
Yep.
So I think unless y'all have any heartburn about that, striking any city court reference is probably prudent.
okay? Okay, we'll move on to social security coverage, 228.
This is probably going to be largely boilerplate language from, I would, obviously a prior ordinance, and I don't think it doesn't look problematic to me. There's some references in there to an old ordinance 79 too, which that's what this one is.
Is it even necessary?
Well,
It is, yes.
I think they do still require that. You know, it's basically one of those mandatory disclosure type things on an employment situation. And I think it's obviously fine. I mean, there's nothing here that I think has changed. So anyway,
Yes, yeah, it's, I didn't have any problem with any of the verbiage in it, so. And yes, we do need to have it, because otherwise, a political wouldn't necessarily be a member of Social Security. But us stating this, then we collect the Social Security and turn it in for the employees, and that way they get the retirement. If we didn't do that, we would be collecting Social Security for them, so.
yeah, I didn't see anything about the language of that was concerning to me. And if the municipal league thinks it's good too, then I think that would fly. Didn't see any concerns other than.
Okay. 2.32, deferred compensation plan.
I just assumed that you guys didn't alter this in any way, you know, down the line. And so if this is the way it's written essentially now, and there, you know, this is still the way it's coordinated, you know, through the trust, if you will, then I think that this is fine. Again, looks very concrete to me in terms of the definitions and all the provisions of it.
Okay, defined contribution plan, chapter 2.36.
Again, kind of the same there. I think it's fine language-wise. And once again, just an interesting little note here, if you look at this, both of these ordinances, the deferred comp and the defined contribution, always are refer to the town of Damascus, and then we get to city judge and call it city judge, city of Damascus. So I'm with Pam that clarification is going to be across the board here clearly.
That was, yeah.
And I guess
We don't have Stephen Hawking.
I was going to say leading into city judge, obviously this does not apply anymore. Either.
No, that needs to be completely.
That's a
deleted.
repeal.
Okay, retirement health insurance coverage.
We don't have that at all anymore.
No,
We haven't, no. We haven't given us.
Yeah,
so that needs to be repealed.
that needs to be repealed. 2.44.
Retirement?
That's 2.44, repeal.
Yep.
City attorney, the only thing that I seen in here, was thank you for your 25 years of service.
15.
Oh, yeah,
Don't
that's
give me 25.
2010.
Then I was practicing law without a license at the beginning of that.
Okay, that was 2010.
The one thing I will mention on this is that we probably need, I think I probably drafted this based off, I think, what my predecessor had drafted. So I might, and again, this is not anything of any urgency, but I would make it clear in there, you know, it says appointment. I think an additional sentence in there to establish, not just that it's me, but that if future city attorneys will be appointed by the mayor with the blessing of the council, something like that, just to put that language in there so the appointment is clarified how it goes, how it happens.
Yeah, I agree with that.
And honestly, if you look at the duties and things like that, I don't know. I'm not suggesting we repeal this ordinance, at least in part, but, you know, again, it is specific to me. So what I'll probably do there, just to make it neutral, if you will, is we'll do an amendment to this. And I'll work on the verbiage of that and get it to
Should
you
we
guys.
not strike the fee, the flat fee?
That's correct, because, you know, it's moved, you know.
Right.
But yeah, I think 2.408 and 01 and 02 can go in their entirety, basically, with the exception of the A, B, and C there under duties is pretty good. You know, that part is fine. I think I would just, again, repeal it to the extent it mentions me. But the thing about that is if you guys hire somebody new in the future when I'm gone, then, you know, you'll do an ordinance to approve that party. So I don't really have any concern about it so much as it just probably needs to be more neutral, if you will. So I can work on some language there and have that as part of our package of amendments that we may end up with.
Okay. Can you have them by our next meeting?
Oh, yeah, yeah.
Okay.
Well, wait, when,
That's
We can
the,
and this next Tuesday is not the meeting day, it's the
No,
following,
next Tuesday's the
14th.
following.
Got it, got it.
okay.
Yeah, I can take care of that.
I'll make a note on that. Okay. Fiscal affairs. Block grant program. Does anybody know anything about this? That would be three.
That was actually the question I was gonna ask too, is
Yeah.
what, is this current, is this applicable?
I have not seen anything or heard anything about this at all.
This is the water stuff. And where we did the, let me get down into it. Trying to. Let's go back up since I got distracted. This just states that we have participated in the past and we would want to continue to do it in the future, so. That we have done citizen participation in the community block grant before.
Is the, is that plan actually filed? That it's referenced in there, Pam, where it says a copy of the plan is attached and filed with the clerks? Have you?
Yes,
Oh, okay,
yeah, ordinance 79-3, yeah,
okay.
that's where she got it from, yeah.
That's the
Well, I gave it to
town,
her, so,
town clerk's office, not the city.
Yeah.
yeah,
But no, I mean, I don't think it's causing problems, you know, I guess we would just need to determine, I mean, if that's going to create any problems to repeal it, then we don't want to repeal it, you know, if there's and I'm not aware necessarily of that being a mandate, if you will. But I do know that when you're dealing with CDBG stuff like that, it's, there's a lot of red tape as you might expect.
there's probably actually a loan attached somehow, some way to it, and that's why that has to.
I see, okay.
I figure that's exactly the case.
This is it.
That's it right there.
Goes on
When was
down.
that adopted?
year was that?
79.
79?
1979.
Started kindergarten. was that?
10th grade, I was a 10th grader.
I was in kindergarten.
Well, if there's no need to repeal it or anything, then we should just.
Yeah, I've got no-
Anything for sure, and there's probably a loan attached to it, that's why it's still sitting there. For the city water.
Okay. All right, chapter 308, purchases. 30801, real property for the town.
I'm guessing that this was
This was an old one.
an annexation too at some point? Is that what,
That's what it looks
This is
like.
property of the
Oh, this was a
water
purchase.
shop, I bet,
got it.
for 1993.
I don't see any reason to lose it. It's fine in there for historical purposes. I guess it, does track there, in that sense, once again, city to town there, but other than that, I think that is okay.
This is the property for the
I think so.
water
I think it.
water shop.
That's my guess. It might be let's see, the fire station was before 1993, so
Block of 6,
I
Brown
think this is
Edition.
probably the water shop property. I'd have to go look at the deeds to see, but
We'll research that and make
Yeah.
sure we gotta know what it is. Okay. Okay, water franchise granted to city.
this is.
31201,
That's gonna be City Hall, the old City Hall. Brown
The
addition. additions.
ground up there on the brown addition?
That brown addition is
Okay.
the old city hall, yes,
All right.
that's what that one is.
Obviously, there's on the water, franchise ordinances, obviously there's a lot of regulation references to Twin Groves in there.
Right.
And I think that needs to stay clearly.
Yeah.
I doubt that any of that has changed other than,
Solomon Grove's probably its own entity, I imagine.
I don't know if they're separately incorporated.
I don't know.
No, it's
I think they're all one.
I think it's just
Okay.
considered,
yeah,
it's one of the
all
twins.
Yeah, Solomon and
Zion
Zion
Grove and
Grove.
Solomon Grove, and then it's all
Then they
one
renamed
city.
it Twin Grove.
They renamed it Twin Groves.
And I noticed on 3/12/04, of course, since this was adopted in 95, that it had a 20-year loan. I don't know if that, that's obviously antiquated language, but I also don't think it's not worth repealing. You know what I mean? That's fine to keep that in there.
Okay.
I didn't see anything else in there.
Well, and it's the plus 20 years.
Oh, right.
Loan plus 20 years, so it's
Right.
about 60 years.
Right.
Max
Yeah.
60 years.
Is there any changes need to be made on the rates, underneath the rates one,
I think it
where it
just says,
says, or it's
that we just determined.
charged by the town of Damascus Association or other designated
No,
users in Twin
no,
Grove?
that falls under our rates that we do every year. So,
I didn't know with this new water rate study and stuff, if the verbiage needs to change any.
Well, it'll all change after a rate study and
yeah,
next
when our
year.
rate study, that's a possibility, we'll just
Yeah.
have to see what they come back and say.
Okay, any other questions on that? Okay, let's go to 316, financing with Arkansas Soil and Water Conservation Commission. 31601 through 31605.
This is it sort of reminded me of that real property clause in that earlier one where it's referring to a specific time of an acquisition or a transaction. It's obviously something that has been, I would assume, satisfied and done in terms of any loans, but I don't know the history there.
Well, the loan is still
It's still
being paid.
existing.
Gotta be
It's still-
repaid in 30 years.
Right, okay.
Yeah,
So I think then this obviously needs to stay.
Yeah.
just stay
Yeah,
where it's
yeah.
at.
Yeah, and I think that clearly the language of the ordinance there that's referenced, that 02-3 and 02-4, those are fine. I think that those, all that looks good.
Okay? Any questions under that? There's all kinds of additions to that on the alphabet down through there, but I didn't see anything that flagged anything.
It's pretty kind of standard language in
Yeah.
any kind of a mortgage or loan document, so I think that all squares.
Okay, let's move to 3.20.
And obviously that was based on I think the election in 2012, was it, Pam?
Yeah,
Yeah.
2012.
And so,
Yeah.
again, nothing's changed there, so I believe that should stay as is.
324, 32401, 32402.
I think Pam can speak to this, but, I believe,
It has the latest and greatest on this one with its $5,000 in 5 years.
right, and I was gonna say, this is some standard language, that has been, I guess, that last amendment, or that last ordinance was 23, so,
Yeah.
again, I think that's fairly current. Same's gonna go for this real and personal property tax issue.
Was there not an increase
On the rate of taxation, or are you talking about on the
S?
on the fixed
Fixed
assets?
assets, but this one reflects, it has
We
the
changed it.
newest one in
It
it.
was,
Okay.
I don't remember what it was before that.
It was like
It was like
25?
2,000 or
2,200
2,500.
or something like that.
Okay.
Yeah, no, and we also added, we had added the, life expectancy exceeded 5 years.
Gotcha.
So even if it costs more than $5,000, but it's not gonna last 5 years,
Right.
it doesn't go on fixed assets.
I gotcha.
Okay.
And then,
Just my opinion on the fixed assets is that to remove them from inventory, they should be approved by the council. I don't know if we need verbiage here or somewhere else.
I almost feel like, Ron, that may be addressed in another section, in the sense that it may, I don't know that, we might come back to that. I definitely agree that, from a procedural standpoint, that's prudent.
Well, it is,
But I think
because
it's-
y'all vote to sell the fire truck.
Right.
So that will take it off the
That
fixed
takes it,
assets. It is that way, but it's not necessarily an ordinance for it. It's in your minutes from your meetings and stuff about you voted to get rid of that truck that we can't repair, and I was trying to remember what else we might have. We haven't done anything else lately, but, well, the police vehicles.
Right.
So
We
y'all,
voted to
it's in the
sell
minutes,
the
so,
That was done before.
yeah, that's the only way it,
We got to vote on it.
yeah. Unless it's something like that might have been on there that came in for obsolete, but even then it's y'all get a copy of it, so.
I think the only thing about the real and personal property tax there is the rate. That may fluctuate or change at some point, but since it was enacted in '23 and I don't think there's been any change there, then that's probably fine to keep as is.
Okay.
I was wondering about that too. That was one of the first things I noticed when I was reading the table of comments.
Well, and we're at the max that's allowed by law right now, so.
Right.
So, if they up it whenever we want to do more, but right now we're.
Right now, we can't.
We can't do anything else, yeah.
Yep,
that's
We're at the max we're allowed, so.
Business license regulations, Title 4.
Well, I don't know much about this in terms of the history of it, but clearly some things have changed, I would assume. And I don't know in terms of, it looks like, when was this adopted? In 2008? In 17 years, you guys are going to be the ones, as residents and everything here, to tell me a little bit about the electricity and how it works up here.
Petty Jean's your only choice.
Yeah, I figured, and I figure, of course, that when I say something may have changed here, it may not have.
I say the only choice, you could get a generator or whatever.
Well, right. But in terms of a public utility, they're it. Yeah. I don't know. The one thing I saw there was the franchise fee. I don't know if that's still
Are they paying it?
correct.
They're paying it, and yes, and we're at the max that's allowed by law on it, so.
Yeah.
And we don't have a, cable television right now, so.
I would feel.
That's the next page.
I would feel like maybe, just this could be me, and Pam, you may remember this, whether you drafted this kind of thing or if it looks like something Petty Jean might have provided. I don't know that.
We copied it from somebody, but.
Well, it always gets copied from somewhere, doesn't it?
It is.
I would assume that they probably, because of what they, the business they're in, that they have franchise agreements with every city that they, serve. So from my standpoint, unless you guys have, fine-tuned on this and think there's anything substantively changed there, then I have no concerns about it. That's right.
I don't see where there's anything in there that doesn't protect us.
No, I mean, you're fine,
I didn't know that was a word.
insofar, yeah.
In so
It's kind
far.
of an old one.
In so far.
You don't see it much.
I didn't know that was a word. In so far.
Well, now people just say it's so
No,
far.
the
you
cable
know?
Yeah.
television one, we probably need to look
Yeah,
at.
that's
too.
what we were.
Yeah, that was my,
Cable
that's
television
what,
is
that's what Jackie and I were just talking about, is that was the first thing that caught my attention was
Yeah.
cable television franchise. And this was actually not that long ago. I mean,
No?
10, 11 years ago, it looks like, but I would assume on this one,
I would say we need to repeal that.
that's what I was thinking as well. I think it's just a whole stock, lock, stock, and barrel, just strike the whole thing.
Okay. Title 5, Health and Sanitation, 504 through 520.
So, on trash collection, because you all,
Yeah, we
From
changed,
time to time we'll amend the rate, right?
every year we amend
I was
the
gonna
rate.
say, so,
So the rates are wrong. It needs to be ordinance 24-2 now, but we're fixing to do it again in November. So really, we need to do 25- whatever it winds up being in November before we submit this. And then we'll have the latest and greatest.
and because of that, because you're going to have an ordinance every year, I'm not sure how necessary.
The actual rates in it.
I think what you can do is, state something very generically there. You could keep a trash collection provision and just say that the city of Damascus, town of Damascus, shall have the authority to, charge reasonable rates month to month and then shall set that by ordinance in subsequent years. And just give this, in other words, take this from being a description of rates to just giving the authority, if you will,
Trash
to
collection
set it.
authority.
Yeah,
Okay.
Save some work.
Yeah.
right.
So we could amend that, and take out the prices here and just put a clause in there that states what,
Changes yearly or
Right.
as
and
per
yearly
latest
as,
ordinance or something.
I'll get you guys some language on that one as well.
okay, thank you. Okay, maintenance of real property, 50801, 50803, 50802, and 04.
Well, these are not terribly ancient ordinances. They came around when I did in 2010, I guess.
These are very difficult to enforce.
Exactly. But that said, difficulty in enforcement, is one thing, and applicability is still there. I think it's still a good, statute or ordinance. I think it's fine in terms of the detail. I think it's fine in terms of giving the procedures, if you will. I don't have any concern about this other than I will say. There is not a chancery court anymore. If you look at 50804 with lien,
Right.
and that's just a technical thing. What we can do there is keep and preserve this ordinance with a slight amendment to it, just to say that is going to be the Faulkner. I would say Faulkner County Circuit Court.
Can we just strike chancery? and
Strike
just do it
chancery,
for-
put insert Faulkner.
Well, actually, not just Faulkner. Hang on.
It should be
That's right, it's just
Court.
district court.
Strike it and say court, period.
I would say Circuit Court.
Circuit court.
Yes, because
Circuit.
you're right, and it'll be within the
Yeah.
judicial district, if you will. But yeah, we'll obviously refrain from a county reference there and just say Circuit Court.
Circuit
Okay.
court.
Other than that, I didn't have any concerns about that. It looks like again there's no problems with that lien state and the rest of that lien portion of the ordinance.
Okay. Let's move right along, 51201, 02, and 03.
So one thing that I considered here was.
Why do we have to have an ordinance when it's so long?
Well, that's fair, and it is prohibited activity no matter what. But it's not the type of thing that's going to get necessarily cited by state police or whatever. So I like it in terms of again, like the previous one, the substance of it is fine. I don't know if those fines are still applicable, but that might be the one provision that gets amended there. But I don't, once again, it's like TJ said, or enforcement's a challenge
Yes.
on something like this, and so
But at least it does, with these ordinances, it does give you
Oh, right.
some,
it's also got a range here on the
Yes.
fine. So yeah, I think that's fine. I didn't have any problems with this. The one thing that I was going to say is we could kind of just consolidate that with the general trash collections, statute. But that's not necessary. I'm fine with it being separate. That was just me thinking out loud. And earlier I was like, well, why don't we just combine these? But it's fine as it is.
all right? 5.16, that includes 5.1601, 02, 03, 04, 05, 06, 07, 08, and 09.
That's right. And, again, this ordinance, was adopted pretty recently, wasn't it, Pam? Not, I say recent, that's always relative. 2016 doesn't sound that long ago to me. So, I remember when this kind of, got implemented, and, I think it's still applicable.
Yeah.
I think it's still, fair, obviously, and I don't, again, think that we've got a lot of enforcement ability there on some of this, but again, I do like the fact that on both of these ordinances that we've just been through, the dumping and unsanitary conditions one, that it gives you as the mayor, authority as well as Will as chief of police.
The 51602 really is beneficial for us to try to clean up town.
Mhm.
It's
Absolutely.
basically the only thing that's got any meat in it.
It does. It's got a lot of substance to it, and I think it covers a broad range of things and problems and infractions. I think everything about the exceptions, the notice, the method, all of that to me is fine. I don't see any reason to alter this one whatsoever because again, it's not that old, but it's certainly something that we need to keep in place.
Is this one not cover dumping or trash?
Do what now?
Is that garbage or rubbish or unsightly or unsanitary? Is
Where you at?
512 even needed with having 516?
It may not. In fact,
All these are hard to enforce.
true.
If you keep these separate though, it gives you, these deal more with the properties that we're having issues with, trying to get cleaned up. The other one, like trash dumping, is to me, is a separate,
Littering?
yeah, it's more like littering.
I can see that distinction, and I think it's it's still, and I don't think it's necessarily redundant. If that makes sense, because I think that now I will say, and this is just me having been through this before, it's not going to be worth an entire sea change here, but there's one word in here that I've always had problems with, which is unsightly, because that's really subjective.
Yes.
I'm not going to sit here right now and tell you that I think we've got to get that out of here, but I don't like it. Let's put it that way.
Hard to prove, isn't it, though?
It's an eye test, literally.
Yes.
But I also don't think that we're going to be handing out a lot of these tickets. And I'm not trying to, I'm not trying to minimize this, but I am saying that I don't think we're ever going to find ourselves, or I'm going to find myself in a position to have to defend an unsightly claim. It's going to be something obvious.
We might need to define unsightly in 51601 as, because when you're talking about unsightly grass,
Mm-hmm.
whatever.
I mean, I think that what might be the thing to do there, I think if we just struck the word unsightly, I'd be okay with it. I just think that word is problematic.
It's subject to your
It is, and
determination.
it's certainly, and everything else, if you look at this, storage of more junk or abandoned, I think there's frankly some typos in this, okay? I mean, junk or abandoned, I would say junk is not the best word there.
Inoperable.
Yeah, there's the word. There's the word, inoperable. So, if we're going to make some tweaks there, I can strike unsanitary. We can redefine junk. It does say, too, unless reasonable out of public view, that should be reasonably. But, again, that's another one word, and it was probably our most popular word in law school is reasonable, and still nobody knows what it means, okay? So what I would say there is I would just strike unless reasonable out of public view entirely, because to me, if it's in public view, that's why the citation's written. If it's not,
That's why it's unsightly.
you may not know. Right, exactly. There you go. It gets back to unsightly. unsighted and unseen.
That's right.
If we want to strike unsightly, it's also mentioned in 508, under 50802, where it says eliminate any unsanitary and unsightly condition.
I agree.
I saw that a while ago. I thought the same thing. I thought, man, that's an opinion, right?
Yeah, and I think what we can do here, and I say we, this is kind of like with town and city, we can do just a good old find and replace.
Yeah,
And if we see unsightly in there, we'll just strike
Find
it.
and replace.
Yeah, good catch. Justin, thank you.
You bet.
The one thing in there that, I had question mark by, well, two of them. One was the amount.
Oh, yeah,
Fine.
on penalties, correct.
Yes, under penalties, 51607.
I saw that and I thought that we should just mirror image what we did in the previous one with it being 100 to 500. If
Yeah.
y'all are okay with that.
That's what I thought.
Need to zone it.
Right.
The other one's 51609.
Mm-hmm.
How does that stand up against the new laws that were passed? I was trying to find Dylan the municipal law here, and I
I
did
tell you
not
what,
find
let
that.
me look on and see. I'll make a little note to myself here.
Because I know they passed some laws pertaining to this that made it even harder for municipalities to deal with these issues.
Yeah, I mean, this is probably going to still be okay. I mean, the abatement. I will say that the one thing I didn't get around to doing was reading that Act 1984, 2005.
Right.
So let me read that and see if there's also been some, changes to that statute. I'm just going to make a note of that. That we may want to change this one. Clearly, there's going to be a couple of just minor changes to this particular, the unsanitary conditions one. So I think there, once again, we'll have an amendment to 516 generally, which will include, additional language about the fines, striking of unsightly, things like that.
Okay.
But yeah, I'll double check into that, Mayor. I want to make sure that if there has been a change there, that we obviously are consistent with that.
Right. Okay. Recycling program, it is no longer in existence.
There's, under 51603, we were just talking, and
Under which one?
51603 exceptions. I would kind of like to see in parcel of land, 10 acres or larger is treated from that. Just leave it at agricultural property.
Oh,
And not add in that any parcel of land 10 acres or more.
So what you're saying is,
Any agriculture, don't determine the size.
I got you.
Well, but
But it says or, it's not and.
Yeah, that's what I'm saying is if a 10 acre parcel of land is not being used for agricultural purposes, we don't want it to not apply to
okay,
this
so
ordinance.
what if somebody's using their 10 acres or 20 acres as, quail,
That's agricultural.
okay, or if they're just keeping it wooded,
Long
I
as
mean,
they're
just
not-
keeping it for a while,
As long as they're not
farming it
putting
or anything.
buses and cars and all that
But I mean,
stuff.
they're not farming it or anything, it's not, I mean.
And
they're just-
here's where you look at what you truly want on exceptions. I mean, I agree that the ag portion of this is, makes sense. And, Brian, this might eventually we're gonna look at the zoning component of this too, and I don't want, ultimately, if the town enacts a zoning ordinance, then that may not apply anymore, so I don't
want to see somebody buy an 11 acre property and throw a whole bunch of junk cars in it.
Oh, right,
Oh, I'm not
absolutely.
saying anything about
So-
junk cars, but it was saying something about
But
the
this-
grass growing.
Yeah, well, this says
So,
though any parcel of land over 10 acres does not apply. This ordinance does not apply to it.
That's right.
So I would like to see that.
You think it should apply just to the
Just
agricultural?
agricultural. Yeah.
I mean, that's for you guys to discuss and decide on. I will say on I understand why that was put in place several years ago, but again, I can see problems there, or at least some argument emerging at some point about, like you just said, somebody's gonna buy 10.5 acres and do
Like a
something.
junkyard.
I mean, I can understand that. I don't know, there may be a better way to string like that again, to just say this ordinance does not apply to agricultural property that's being farmed or otherwise used for agricultural purposes, or, and we can leave the or we can leave the or off, or we can come up with some different language there if the council's pleasure is to do something to modify that. But if it's just a striking, then we'll just strike it. But
In my opinion, like wooded areas, it's an agricultural area.
yeah, well, you get a good definition on the front of the agricultural property,
Yeah.
and I think that does help. In other words,
It clarifies what.
it really does, and it like y'all said, animals, it's on there,
Orchards and
training.
woodlands is there.
Yeah, so I feel like that right there, because we got a strong definition. Then I agree that, ag property is well defined, but then in terms of the parcel size or not one, then that, you guys can make a decision on that. I don't have any heartburn one way or the other. It's, like I said, if the town's eventually gonna potentially enact some zoning, then again, there may be some governance that comes in and replaces this or changes this in some way. So, this can always be changed later, any of this can, but for right now, whatever y'all want to do on that, you can make a decision, and y'all can confer on that.
So now's the time to do it if we're gonna do it.
Yeah, I'd just like to leave off the or there.
I don't know that it's necessary, and I don't know, again, that you're going to run into any genuine issues with this ever, in terms of somebody. And I actually, again, there's times as attorneys, it's like everybody thinks we just want to, spill a bunch of words out. No, I like to keep things simple. And if you can strike stuff, I believe in striking it, because the more you say, the more likely it is to conflict with something else in your statute, the more likely it is to lead to confusion from somebody or arguments. So, and again, 10 acres is also kind of an arbitrary number, let's face it. I don't know where that came from, and I don't care. It's just that I don't know that it's, that seems to me like a weird line to draw.
Yeah.
I think probably the reason 10 acres is in there, because that's the minimum you have to have if you don't want to get a permit for septic systems.
There we go. So it's a health department
Yeah, through
thing.
the health department.
Okay, then that makes sense. Yeah. And so with that in mind, let me check into whether I'll say, I don't know.
I don't know that would affect this.
It doesn't. I was about to say, I think that that's probably is an explanation for that, but I don't know that it's, again, I just don't think it's necessary. I'm kind of like Brian, if it's in there and it's not being functionally used anyway at this point, I'm not saying it won't be, but let's carve that off if y'all are okay with it.
Yeah.
Who, is anybody opposed to scratching that? Anybody? Let's scratch or number 2, and number 2. Okay. Okay, I think it covers that one. Chapter 5.2, recycling program.
Just wait for it. Gone.
Gone. Repealed. Okay. Animals and fowl, Title VI, there's nothing on file that we have right now. Pages 43 through 50 were intentionally left blank for future ordinances. Public peace, safety, and morals, 704 through 720. Title 7, Chapter 704 curfew, 70401 was repealed and replaced by different ordinance. 7402, 03, 04, 05, and 06.
This was enacted several years ago. I see no reason to change anything here. We don't really seem to have an issue with that as far as I know, but,
We have in the past.
right, oh, absolutely, I get it, but, you know, this is, again, kind of mirrors a lot of typical curfew statutes or ordinances, and so I think, you know, unless you guys see any changes to the hours or anything like that, I think it's fine as is.
Okay, chapter 708, fire protection outside city.
And again, you guys will know more history here than I will, but this is an ancient ordinance, but you know, and so there's numbers in here. There's the references to the city, obviously, that would be changed. Other than that, again, it's a historical thing, you know, so I don't see any need to repeal it. If you note 70805 repealed ordinance 98.5 or 98-5. And I don't know, Pam, I know that these call costs and everything have changed, right, quite a bit.
No, this is actually, it's the 23.
This is the 23.
This is the 23 one. so
All
this
right,
is-
all right. So we are, like I said, it started with an old one here, but
Right.
Yeah.
the new one has
The new-
put
the
all
rates
these
and fees
provisions
is
in
off of
place.
23, and
Rates and fees are 20.
yeah,
Yeah, so I
Everything
see,
before that though is.
I see no problems with it if y'all don't.
We have a mutual aid program in there. Okay. All right, anything else on fire? Okay. 712 billboards, limits and penalties.
Haven't seen a issue with this, but looks like 20 years ago it was one, or at least everybody wanted to protect against it then. I don't know how you guys feel about it now.
They're riding up here outside.
That was kind of what I was, you know, I mean, this is again, you know, sort of I don't know that you can actually put this under public peace and safety.
Yeah.
That's my concern.
Yeah.
And here's my thing. I would not want, first of all, the highway department's regulations are going to probably prevail over some things, okay? And with that said, I've got no problems with it. It's not, you know, a functioning ordinance in many ways, but I also would like for y'all to figure out whether you want to, you know, continue this prohibition, if you will, or not. If you do, it stays and can stay intact, or if y'all want it gone, it can go. It's really, this one's at y'all's pleasure, but
we get calls and always say we have a billboard, you know, ordinance prohibiting it, and that's the end of that.
Am I
so.
dreaming that there was something that happened a few years ago where
It
there
was
was
the
a sign
sex.
wanted to be
Thanks,
put
It
up?
was the sex or the
marijuana
marijuana or something.
Yeah, it was
And we
gonna
stopped
affect the
it, yeah.
vision
Yeah, the vision.
from
There's
seeing
something.
pulling out on the highway.
I say leave it in there, Bo.
I mean, I don't have, like I said, this is, if you guys feel comfortable with it still, then it rocks and rolls on.
Yeah, if you open it up, it's gonna become a wild, wild west.
Now, the one thing there again, maybe for consistency's sake,
Yeah.
I like the idea of that fine being 100 to 500 range
Yeah.
instead of 25 to 100. That's pretty antiquated. So if y'all don't have any heartburn about that, that's the one change I would make there, just to be consistent with other
That was
ordinances.
a question mark I had on fees, under penalties. So let's do the recommendation from 100 to 500, same as the others. You agreement with that, Bo?
Yes.
So if you violate it, you get fined, but you get to leave it up or you gotta take it down?
Yeah, take that.
Gotta take it down.
Yeah, and
Is that worded in
you
there?
know,
That's
great
not in
point.
It just said you'd be fine.
It just says you'll be fine.
The one thing that it says
Each
though,
date
is
during-
each date during or on which a violation occurs shall be considered a separate offense.
Okay.
So-
It adds up quick.
Yeah, it adds up, so they better take it down then. I think the
Yeah.
implication is clear enough there.
If they don't, we'll just let them pay us $500.
There you go.
Pays $500 a day and you can, Leave it up.
Well, if they've got any sense, they're gonna call and get a permission to put it up before they do it.
Absolutely. And
Sense
yeah,
is
sense is
one
like
of
you
those
just said.
words.
It's not going around in droves.
Kind of like unsightly.
Yeah, kinda like unsightly, yeah.
And so far, yeah.
Okay, we're to the noise ordinance.
All right, noise ordinance. You know, first of all,
Check break.
yeah,
We need Maggie for this one.
Enforceability.
Yes, enforceability.
Need to go get Maggie.
it is damned hard. Let's put it that way. Now, with that said, you know, I don't have any, like, for instance, these, you know,
There are
examples
power-
of noises.
domestic power tools?
I cannot say if any of that. I don't love this ordinance. Okay, not critiquing it. I understand why one is necessary, but man, what's audible disturbs a reasonable person of normal sensitivities. You want to talk about subjective?
Oh, yes.
That is not something that any of us can define as we sit
No.
here tonight. So
Examples, loud parties, though. I mean, I understand where you're coming from.
yeah, what's loud? What's loud? And again, you know, if you look at, here is the way I would pitch this. I would repeal this ordinance, okay, and I would replace it. I don't think there's a ton of urgency to that. So what I'd like to do is, because I know y'all want to probably, you know, again, move through enacting things and getting them official, you know, in a couple of weeks here. So if on this one, my initial impulse is to say repeal it, because there's a lot of it that I just don't think is good. And subjective and ancient in its sense. The thing is that if you look at, I want to replace it. Let's put it that way. I want to replace it with another noise ordinance that's maybe a little simpler, a little bit more streamlined, and then you guys can adopt that in the future if you want to. I don't think it's something that we have to front burner simply because it is not really in a functioning ordinance like some of these other ones.
It's non-functional.
But I think you need still, again, just like with some of these other things, it's better to have it than not.
Didn't we just do something not too long ago with sound?
We did.
To protect us from certain
Industries.
industries that are
yeah.
extremely loud.
Correct.
If we repeal this, is that gonna open us up for somebody to move in before we can put something else in?
Well,
this one doesn't.
This one
include
doesn't
that
Specific
ordinance.
to.
That one was specific?
yes,
Okay.
yes.
Okay.
And so
As long
I
as I know
think,
that, I'm okay.
yeah, very good point, Justin. I think that you're gonna have, again, a lot of these things are gonna be kind of boilerplate and, standard issue type stuff, but then there's always gonna be certain things that are, exclusive to or unique to Damascus. And in this case, noise ordinances from town to town, city to city, don't vary that much. I don't know, this one looks like one that was probably plucked from another small town somewhere, and 20 years ago it might have been okay. I looking at it now, and I feel like there's some problems with it.
Well, for one thing, you have to have the sound instruments to test.
Yeah.
I mean, because you got to prove it.
I'm glad Will is not here, because if there was a discussion about him going around and finding noise ordinance violations, I don't know that he would want to.
You got a barking dog?
Well, and that's the thing though, there is that. Like,
Yeah.
you cannot understate the importance of having something like it. But again, enforceability is a problem. And I think Will has actually, he's explained that to certain people, at times. And we've had officers and mayors that have had to say it to other people before. It's like, hey, the best recourse for someone who is dealing with this, in some constant fashion is a civil complaint.
Yeah.
And,
Try to go talk to them first.
there you go. Yeah.
I'll
you
say
just-
I'll be in violation of this with specifically the barking dog,
yes.
as long as we have coyotes.
Yes, exactly.
Or,
Exactly.
well, who's in violation? When I run past these people's house and their
Yeah.
dogs start barking at 5:30 in the morning,
Yeah.
is it me or is it their dog?
You're disturbing the peace.
I'm always telling them, shh. But
Run quietly.
they don't listen.
But on the other hand, you've got to have that in neighborhoods where
Mm-hmm.
somebody just doesn't take care of their dog, and
Yeah, well, and honestly, I think I understand that we don't want to leave a gap, so to speak. So maybe, well, I might be able to come up with some language here before the next meeting. So just for right now, let's say that we want to repeal that and replace it.
Yeah, that's what I put on the note. Repeal and replace.
Way too wordy.
Yeah, there's way too much.
Yeah,
Well, and there's also just, again, I've never seen an ordinance, frankly, that tries to give you examples of what a certain tool or sound or whatever. I mean, it's, fine. It's not that it's poorly worded or anything like that. I don't think that it procedurally makes a lot of sense to have a lot of this stuff in there.
Yeah, because my mower will break it, and then I can't mow my grass, so then I'm gonna get fined
Then
for
you're
my
gonna-
grass will be off.
Yeah,
we can't cut a tree down because chainsaw's
You're
too
gonna make
loud.
money off of Gilbert.
All right, let's go on to 720 Identity Theft Prevention Program.
Is this necessary?
Is this, what is this?
Yeah, well, I remember the adoption of this somewhat. Pam, there was a history with this, was there not, in
Yes.
terms of why this got put on the books?
Yeah, but, I think it had to do when we started taking credit card payments.
I believe that's correct, and there is a reason for it, and it really comes down to three little letters there on page 58, kind of in the middle of the page, CFR, which is the Code of Federal Regulations. And when it's something federal, it's kind of like our Social Security clause, you kind of got to have it sort of thing. I looked at this, and it's a very comprehensive ordinance, and it's clearly one. As a result of that, I can tell I didn't draft it because it was really thorough. No, I mean, I looked at it and I was like, man, clearly somebody prepared this one, and we had to
It was our
implement it.
credit card
It
company
was.
that we were
Dealing with.
Yeah.
dealing with, and they provided this, and we had to adopt this because they have to have it for to meet the federal
It's
requirements.
auditing
for
stuff. It really
identity.
is. So
Yeah.
it's a compliance thing, and therefore I say it stays.
And we still take credit card
And
payments.
exactly.
Yes.
That's why it's several pages long.
That's why it's so long.
65 goes to 65.
Goodness.
Yeah, there's a few pages of it for sure. That's the last one.
Yeah, I think it's
That's after.
64, 65. 65, vehicles and traffic.
All right, truck routes. Again, kind of an older, somewhat older ordinance here.
I mean, if it's marked, no fee.
I
It's kinda
honestly,
like a littering.
We had trouble with them coming through on our city streets, cutting through from 285 to 65 on Fire
North Tree.
Station and North Road.
Yep.
So we did this one so that it was no through trucks to prevent that traffic from coming through there and tearing up our streets. That was
Is there
during
a sign
that
there?
gas oil drilling whenever it was
Uh-huh.
going on.
I was gonna say, there's context for
Yeah.
that.
But I
But,
don't know if it's
you know,
still
'cause
is.
I haven't seen.
You know,
it.
I haven't either.
A what?
I haven't seen a sign there, so.
Yeah, I haven't seen one on.
Don't see any point. in
On Fire
removing
Station.
it if we
One
don't
on
need to.
Lewis.
I see there's one on Lewis, but
Yeah,
there's
there's
not,
one.
that's the only
No.
one I've
I
seen.
think
It
it
does
needs to-
protect us in case.
It needs
we
to
do have
stay in
that issue
place.
again. We
Yeah.
can go put up a sign.
Yeah, I mean, the one thing here that, once again, the penalties part of this, we might amend that from $5.
Yeah.
If you guys are okay to do the 100 to 500 range across the board on that,
Yes.
let's do that.
Cause that truck that I got hung up on,
Uh-huh.
I don't remember a sign.
It may have been knocked down by now, but
I'm gonna make another
On North
recommendation
Road,
on the penalties
over there.
there.
Okay,
Where it says, or driving privilege is suspended for a period of up to 1 year or both. I am actually not certain that that the judge can suspend a license on a city ordinance violation. In fact, I'm fairly certain he cannot. So what I really think what we do there is, instead of driving privilege is suspended for a period of up to 1 year or both, I think we put or other penalties in the discretion of the court.
okay.
Just to keep that from being a problem. That's on page 65. Yeah, we didn't jump just yet.
That makes sense. Okay.
All right.
We just
Unsafe
did this one,
driving.
didn't we?
Yep, we've just redone it, and
Yep.
so this all is from 15, and that will all be replaced with the new one,
Yeah,
25.3.
those are done.
That's
You
right.
have a copy of it.
It's in here, yeah.
I was gonna say, I thought we were.
This is towards the back, but it'll be replaced. This
Yeah,
one's
replace the
replaced.
one that's in the back.
Replaced with new. Okay,
25-3 is that new unsafe driving one. if
Yes.
Somebody wants to.
I got more than a little confused by the headings here on 68.
yeah, I did too. Acceptance of streets.
Yeah, I mean, honestly, to me, I don't understand why even streets and sidewalks exist. I mean, I should say, sorry, 9.0.
Able to run on.
9.04, that gives you the standards of any new subdivision or
Correct.
streets going in.
Correct, yeah.
That's kind of what it covers.
Well, and I think that, again, in terms of that part is fine.
Yeah,
This is just more of a labeling thing, I guess, for the way they've done it, but, you know, we probably just ought to call the Title IX streets and sidewalks, and then strike that chapter 9.04 acceptance of streets, and just have those two, you know, these two things marked off, basically, and just have it streets and sidewalks, and then start with standards right there.
I'm missing is there no requirement to put in a sidewalk with new street, or that's what we're looking?
I didn't think there was anything on a sidewalks provision in y'all's. Yeah,
We don't have any.
we don't have
Yeah.
any
I
on
don't have
our,
many, but
New
the ones on
subdivisions.
65 is all that I know about.
Right.
That
I would
was
like to see any new
state
construction
standard, so.
well, it's
require.
right, and so here's where you get to that, which is doing your zoning that way.
yeah.
And you know, and so once again, when that ship comes home, now you can still deal with it right here. You know, you don't have to have a zoning ordinance to restrict something like, or you know, to put some provisions in there. I just knew that there wasn't anything on the record yet. If
No.
you guys get to the point where y'all want to entertain that, we can draw something up.
I agree that needs to be
Because you really don't have, the thing is, without a sidewalk provision, you don't have any standards that you've adopted, you know, for the width and the character and the, you know, quality of construction and all that. So, like I said, Brian, I think that's gonna tie into some zoning components where, you know, you got some governance over your residential developments. You can put it on your commercial ones and make them have sidewalks too. I mean, you know, I think that's kind of the world is your oyster approach of a zoning ordinance when y'all come around to it, if you do.
There's some verbiage in that that I'm not quite understanding, maybe I'm just reading it weird, where it says, but that double chip seal may be substituted for asphalt until such time that the town of Damascus shall be to reseal streets.
Good, yeah.
What is,
I think that's supposed to be begin.
begin, oh, okay.
yes.
Okay, I was like, maybe I don't understand.
So,
Yeah.
you know,
It's
we'll have
supposed to be
some,
begin.
we'll have some typos in here, and that's another thing. You guys go ahead and please, I mean, I know we're going through it already tonight, and you may go through it again and again and again, but if y'all see any other typo type stuff, just, you know, feed that to me and Pam, and we'll make sure that we make those changes.
Well, I just thought maybe it was some type of lawyer term I didn't understand.
No, that's just a lawyer whose finger slipped off the key the wrong way.
Autocorrect.
That's right.
That's probably autocorrect, honestly.
I'm a co-pilot. Fix
Well,
it.
this is ordinance 04-3. I don't think it was autocorrect then.
No, I don't think it's.
Well, and also being's a word, you know, there's no grammar correct.
That's it.
Yeah.
We've got co-pilot now. We'll
Yeah.
co-pilot this,
Yeah.
so.
69 through 78 is left blank for all those future ordinances. Title 10, utilities, water and sewer, 1004, 1008, water revenue bond, 1012, water uniformity utility billing procedure, and 1016, water and sewer rates.
Good news.
All
I
of
think this is all.
The good news for you guys is this is the bulk of this book almost.
Yes.
And it's pretty much,
So long.
it's standard issue
It's standard
and
stuff.
we don't have anything to change there.
Anything to change till we get to 115.
And there you go. Well, actually, hold up.
There is,
And because once again, I just wanted to be consistent, I think. On page 114 there at the bottom where the penalty is announced, once again, we've got a $100 fine plus court cost. I don't know that this is again ever gonna become a problem, and also that's in unlawful connections there. You know, what I would say there on those unlawful connections and that penalty is we again give the range of 100 to 500 there.
I had,
Do we need to add in there too that each day is a separate fine too? Because I'd rather pay $100 fine for an unlawful connection than $2,000
I get that.
to illegally.
Exactly, so.
Until it adds up past $2,000.
You're exactly right there, Brian. That does not give enough clarity to that issue. And I'm glad you saw that because earlier when I was looking at this, you know, I was like, all right, this is, you know, run of the mill, but that language is just not, there's not enough there. So this would require, basically, as I see it, 2 simple amendments if you guys so choose, which would be the unlawful connections, make the penalty $100 per day, and we'll mirror the same language that was used earlier in that other statute that, you know, or ordinance, and then the same would be true on penalty if you guys, it's so, if you look at 10-12-14, that's for the service fee, if that's not a penalty, okay, so I guess that stays at 100, right, or is that?
well, that's for someone going out there and just connecting up to our water.
That's in addition to other.
Right, well, that's one on tampering, it says in addition to, other applicable fees. And
Well,
then
it's
it's
on
on
the
unlawful too, in addition to all our connection
Yeah.
and reconnect fees and penalties. Okay, so actually, there's what we need to say is actually where it says and penalties. That is not on the tampering provision above, so I'd like to add and
Yeah.
penalties there, just for consistency's sake.
Yes,
And then the penalty to amend to $100 fine per, you know, again, per day. And, you know, again, give the range there. I think we go to 100 to 500 because, as Brian said, somebody may not have any incentive to do much at 100 a day, or at least not quickly, you
Right.
know.
you charge 50 and
Yeah,
it won't matter.
exactly.
So we turn check charge to 25?
Yes.
People still write checks.
Uh,
Yeah,
and
I do
we
still in
get
business, but I don't have to have written a personal check in months.
Yeah.
Other than that, unless you guys saw anything else that caused y'all any pause or questions, you know, I think that ordinance, when it was put into play, was properly done clearly, and it's still applicable now as much as ever.
The 10, 12, 17 also do. I don't know about the fees there, you might want to look at that just to see.
No, on the fine there?
Yeah.
Yeah, that's one I want to change to 100 to 500 and
Okay.
give that range per, and
Per
again,
day.
do a per day clause on that.
Okay,
So what we'll have here is just an amendment to sections 10-12-14 and 10-12-17 that we just talked about.
and the rates on 10, 12, 13. You're gonna change that too?
On tampering, yes, we're gonna add and penalties there. Is that service fee, when it's tampering, charge the service fee of
300
100?
now.
It's 300?
300, yeah.
Wow.
It's 300, and that's in, somewhere.
That's in our fees underwater,
That's
Yeah.
gonna be, so basically,
Yeah, it's in this ordinance for the
water and sewer rates.
water and sewer rates.
Next,
Fee to responsible party for damage to water lines, other water system property, and or water loss, $300 plus cost.
so that, to me, these they're not lining up with our others.
yeah, I want some
We could
consistency
combine those into
there.
one ordinance, so we're not having to look at multiple places to make those changes.
Brian, say that again. You said combine them into one ordinance? Or what are you talking about? Which,
What if we just, what if any amount is removed from this, and then we set our penalties and
you
fines?
set your rates and everything through your ordinance, right?
within-
And so,
Yeah.
so I think here what we might do, to be honest with you, is let's omit on both 13 and 14. This is my suggestion. Y'all tell me if it's good. Omit the service charge language of either one of those and say that it is a service charge to be established by the city council from time to time through its rate ordinance, something like that. I'm just gonna make little X's on that so that I plug that language in there. So once again, we'll I think that's a good point, and I think that's a good idea, because again, there's no point in making reference to an amount in a statute or in an ordinance that you're gonna
Yeah.
constantly amend to change the amount.
Exactly.
So,
Anybody coming back and trying to fight that in court.
That's right.
Well, this one says.
Yeah.
that's right, lack of consistency is
Yep.
not what we want, so that's why we're doing it. Yep, good,
So we
good
need to
call.
make sure we put the per day in the rate, on the rates one then.
And then dovetailing into your rates, well,
Yeah.
y'all do this from year to year, so, you know, or
We're just
maybe
gonna remember to add a penalty section
Yeah, and these,
within.
your water rates and all, and and like Brian said, the penalties, those need to be added into this one also.
yeah.
So
Well,
every-
here's what we can do on that. Are y'all gonna have an adjustment to this soon, you think, or? is
Oh,
there-
yes.
Yeah,
I was gonna say,
in November.
then, if that's coming, then what we'll do is just y'all adopt that one when the time comes, and we'll add we'll put some penalty language in it.
Okay. All right, buildings construction.
All right, couple of things here on the building code. You know, I know you guys still do the $50 permit and all that for, the building permits, and y'all have everybody, you know, come in and do their thing, and usually it's not an issue. I will say, I'm looking at, on the standards, it says all buildings as defined above will adhere to all Arkansas state building codes. That's pretty generic. I don't think that that's a, you know, problematic language, but to me, there is not really something called the Arkansas State Building Code, you know, and so what I'm saying is I want to tweak that to change just the proper authority, if you will, okay? As for the building language itself above there, any structure constructed or used for a residence, blah, 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 that's pretty good. You know, I think that,
There's a lot of stuff constructed around here that they didn't come get permission.
well, of course, I'm aware that some things, you know, some people did not get permission, they got forgiveness later. But with that said, I don't really have a problem with any of this. I just want to make that one amendment.
I've never seen anybody come in and enforce it.
I'd like to see an amendment in,
The penalties part.
11403, and
But it's on here,
submit detailed
and
plans.
we've got lots of swimming pools around.
Um,
That's all, I just was looking at some of the.
because
We get some really flimsy ones. I've seen some
Yeah,
applications.
we don't want somebody coming in, I don't know, next, and again, that goes into zoning ordinances, but you don't want somebody coming in, building something that's completely abstract from
Right.
the surrounding properties.
And so what I would say when you say submit detailed plans, that's a word that I actually think is not that much subject to subjectivity, if you will, or opinions. I think it's either detailed or it's not.
Yeah.
And so if somebody comes in with a postcard basically and says, I'm gonna put up a 20 by 40 shop building, well, that's not an application, you know? I mean, it just isn't. And so I think detail's a fine word to use there, and I think a good plug in there.
So we have to have a building permit to build a fence. So like these farmers, if they want to put a barbed wire fence up,
That's what, I'm sorry, some of this, I'm like, the road,
privacy fence.
you know, we got the guy up here selling his
It's up there,
vegetables and
Yeah.
Pruitt's.
And-
He hadn't got a permit.
And here's, that is,
Nobody's got a pool permit. No, never have I approved a pool permit in all my years. And I know that there's swimming pools in town.
Mhm.
I might say, like swimming pools. An above ground pool is completely separate. It's a different thing.
Yeah,
It's a
but it's,
different beast than an in-ground pool.
Yes.
yeah, it is. That's
I had
right,
to
but I
sue
don't
some,
know.
I had to sue somebody in Conway, y'all, this is, sidebar. I have a couple that bought a house and there was a pool in the backyard. It looked nice when they went. It was the summer and everything seemed fine. They had bought it, they were living there a few months and all of a sudden they're seeing this liner tearing away and they're seeing, some signs of really quick wear. And they get a pool guy to come out because they don't know anything about it. And the people had dug a hole and buried an in-ground pool, an above-ground pool in-ground.
Wow.
And the pool guy came out and he said, I believe it or not, he said, I've done this before. And I was like,
Wow.
somebody screwed somebody over that way before? Because they didn't tell anything about it. They didn't say this pool is made for above ground and is now submerged. And it's clearly not. You can't really, but the frame was good enough that the guy could come in and do, repairs, but it was going to be about a $30,000 job. Yeah. Anyway, so I agree that
I
you
just
may
know
want
that
to.
we have not approved anything ever for a sign,
Awnings.
awnings, fences,
Yeah,
swimming pools, those have never come to council.
and I don't know that you
But I
want
don't
to take
know.
them out either,
I don't know.
Also,
because if somebody does put up
Trashy. Yeah.
a 20-foot fence in the middle of a neighborhood, this gives us the bite to say, hey, you need to take it down. It wasn't approved.
well, what I would say,
But we need some kind of agricultural exemption in there too for fencing, I also believe.
And my question is, if you have detailed plans, who's gonna review those detailed plans? Who has the background to say, yes, this adheres, or no, this doesn't adhere?
It's gonna have to be a decision by the entire council.
yeah, I think that there's some of that's just the nature of the beast, that you're going to have people on a council that are all from different walks of life, and you're right, they may not know specs from something else, but I think this needs to be in there, okay? I do think it's a valuable thing to have, but there are definitely some things that are problematic about the building provision itself, because it is the only definition there, and I'm fine with it being the only definition, but the definition's got to be a little better. And also,
Roadside stands.
And I know we're gonna.
yeah,
Do people build mobile homes too? I don't know about
well,
that.
and so what I was going to say is, what my belief is this: if you look at or accessory there too, and including, let's go down the list here. I'm sorry, but you guys don't regulate porches or decks
No.
or pools, okay? And don't have any real interest in doing so. So I say you strike those first three right there.
Greenhouses?
Now, greenhouses, the reason that to me,
My
well, you got
greenhouses
people
will
coming,
pop up.
right, exactly. You got people that come in though on, their metal buildings, and to me, that's kind of similar.
But some people do a small little thing just to keep their plants warm for.
Yeah.
Mine is a pop-up
So how do you-
thing. It's
Yeah.
like little.
So how do you say what size?
You strike it.
I had to keep
You strike
my,
it.
I had to keep my pineapple alive for 15 months to get one pineapple.
And honestly, stables again, I don't think that's an issue. Now garages, I think that can stay. That could be ancillary to the structure, and I think that they should get a permit for that. Have some people in the past not done that? I'm sure. But I think to regulate garages is appropriate given their nature, so to speak. Roadside stands, I don't have any heartburn about striking that. I do think that you could say here, mobile homes, once again, y'all have mobile homes, and so I don't think that's applicable. And where we have similar structures, that's too vague, frankly.
Do we want to allow a mobile home in a neighborhood where there are no mobile homes?
Yeah, but that shouldn't be under,
That's gonna go to your zoning.
yeah, that shouldn't be under
Yeah.
a
I
building
don't know that we
permit.
take it out just yet.
That's why we need to form a planning.
Yeah, I think when you start talking about, how you wanna regulate, construction, it's really gonna apply to new construction from here on, everybody else is gonna be, as they say, grandfathered in with something. So as far as I'm concerned, because you don't have the zoning ordinance, this needs to stay, but it definitely, and you guys can, start coming up with some other, language with me on that. I'm not plugged in enough to know what is and isn't a problem here in Damascus on these kind of things, but fences, walls, signs, and awnings, I mean, you're never policing that, frankly.
No.
And you shouldn't, as far as my estimation. You got resources that are limited, and you definitely don't want to be going out and being code policemen, any of y'all. So I think that the easiest way to do that is to pare the building definition down to any structure constructed, all that's fine, or accessory thereto is fine. And what I would do is strike that and there, and that including too. Or actually, no, strike the and, sorry, leave including. Say including garages.
Mobile homes.
Well,
mobile homes are not being constructed.
no, right, and
This
that's
is just a building permit.
Yeah,
You're
and
not
so-
gonna get a building permit.
And so what I would say is including garages,
Similar structures.
outbuildings, because y'all do get those requests from time to time. And I think that's important to keep some, some teeth into
I think
there.
garages and similar structures would be okay.
Well, I've seen and I've used outbuilding a lot in just a lot of, covenants and stuff, because you're gonna get a lot of questions, and outbuildings tend, if you look at general definitions of those, it encompasses shops, whatever you want to call it. You could go, or you could just say, or accessory structures there too, and leave it at that. And actually, that may be the thing to do.
Yeah.
Just omit garages altogether. I think you won't run into. I know some people might even argue about what is a structure, but I think that most people are not going to go that nitpicky. So, in short, if I were making the recommendation, I'd say any structure constructed or used for residence, business, industry, or other public or private purpose, or accessory structure thereto. And then leave the rest of that sentence out and click completely. I think features which are structurally essential and connected to the structure shall be considered as part of the structure within the meaning of the ordinance. I got no problems with that.
Right. Because that becomes part of the fixed property.
That's right. So if y'all are good with some of those tweaks, that section can just be, again, updated a little bit there. The penalty there, 25 per day. I think y'all should at least boost that to 100, frankly.
That's what I had written down is 100.
But yeah, let's do that.
Yeah. The only complaint that we've had about getting building permits is that we don't supply anything for a building permit. We don't do
That's the
building inspections.
thing, we ensure that somebody is not gonna come in
Mhm.
and build something that is not.
I agree,
Yeah,
but I'm just telling you, this is the complaint we get.
yeah. Well, I think you're gonna get that. You know what I mean?
Yeah.
It is sort of the nature of that beast is people are gonna complain if they have to pay $100 to do anything.
Yeah.
And these days, $100 doesn't get you very far, but 25 sure doesn't get you anywhere. So,
That's right.
It's,
um,
it's the price of the protection of
it is. It's 100%
city ordinances, town ordinances,
And-
rather than being in the county and
And here's the funny thing
not being able
about
to
it.
say what goes up next to you.
It's $50 on the front end. So, if
Yeah.
you just do it right, you ain't gonna have a problem. But they say that about all these ordinances anyway.
Exactly.
We can move on to the energy code.
Yep, let's
And it, to my knowledge, there's been no change to the 24 Arkansas Energy Code. I'm going to just confirm that there's nothing that's gonna consider me, but otherwise I believe that statute is fine, or that ordinance is fine.
Okay.
Okay, condemnation and removal. We've talked about these things a lot. We've mostly talked about it in terms of, again, how do you enforce it? And as you said, Mayor, earlier about, any changes to the law. that this is gonna run us afoul of. As it is written, okay, I don't have a problem with it. You know why? Because I wrote it. No, no, I don't know if I did write this one, but it's from 17,
Probably so.
and I think I might have, but here's the thing about this. This was about, less about enforcement, more about procedure, and more specifically about, giving the city more authority than it had at any point to do something. Now, again, 8 years later, have we had a lot of traffic through the courts on this? No. But, I mean, you guys can look it over and tell me, if you think there's some other things that we need to implement there. But, again, it's kind of like a lot of these, it's kind of, Brian, there's been a few of these that you're like, well, if we're not using them, we still need them. It's like you said, it's like I don't want to go without. And so this is, I think, worth keeping. But if you guys see any amendments or changes there, let me know. And we actually, at that time, we imposed some, I think one of the things we did to change and adjust this was to, as you said, you can see my imprints on this in some ways because I put $500 per day. You can tell I'm aggressive when I get to my fines here. But that's kind of the way that's this was modeled after similar, ordinances, and I think it's fine. I hope we don't ever have to use it, but there's clearly some problems that do come up.
We're getting closer to it.
There you go.
The only question mark I had on this was 11205, where we reference a building inspector, which we do not have.
Oh, correct. Let me see if we had.
What would it take to get somebody certified to be a building inspector, one of our employees?
They have to go through quite a bit of training.
Quite a bit.
Hey, look, if nothing's perfect, and I'm not even perfect. It says it will be town down, not torn down. So see,
Yeah, I saw a town down there.
town down.
There was on a corrected 17.
There it was. You're right. You're right. I think it will be. What we can do is say if the house, building, and outdoor structure constituting a nuisance has not been torn, blah, 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 blah. Building or structure constituting a nuisance, it will be torn down and or removed by
Building inspector.
by.
But, I mean, is that not something we can just contract out?
Yes, that's what I was going to
We-
say. Is
yeah.
an agent or representative of this at the city's discretion, or
I would drop though the building inspector and put down a duly assigned representative.
There you go. Exactly, something like that.
That would cover
we
the
can-
whole
we can do
aspect
that.
of
So
it.
we need to remove that from the next one too, the
Yeah.
building inspector.
Correct. Also,
Yeah.
I don't think there were any other references to the building inspector specifically. I was going to say it will be personally torn down by the mayor, but if you want that.
Give me a track, I'll be glad to.
Yeah, as long as you got some equipment.
Some of it, you just really had to bump it, and I think it's all.
Yeah. All right, Title 12, Parks and Rec, Reserve, nothing there yet.
Planning and zoning may materialize at some point.
Yep.
Now, I will say on the annexing, vacating, and rezoning property provision, again, there's a lot of historical things here, of course, about these annexations, and the one instance of vacating property. So the rezoning statement there, if you will, you don't even have to have that in there, rezoning property 140403, because ultimately that's going to be covered by a true zoning ordinance that would be adopted later. So that's the only thing I see there is to just make sure that we get rid of I think what we would actually do here, to be honest with y'all, is just strike 140403 and reflate and name that instead of annexing, vacating, and rezoning, just annexing and vacating.
Okay.
Now, I will say that Title 14 is called zoning. So let's change that too. And I think,
Well, you got
let me look at
Title 13 under planning, and then you got Title 14 under zoning.
that's also true. I don't really,
I can't say this is just a standard that they use.
Right.
That municipal league has developed for all
Exactly,
the cities that they do for.
So I honestly, we could leave that. We can. We actually can leave it. And we can just say that, just the zoning provision there, 140403 is reserved. So we'll just keep that in abeyance until y'all decide to act.
Okay.
Flood prevention program, all I can tell you there is that's gonna probably be something that somebody else prepared at the highest levels of government, and that's a good way to end the, old ordinances on it.
Yes.
And then, as Pam mentioned, we've got the most recent ordinances that have been adopted the last couple of years here, so where those need to be integrated, of course, we will do so. And I did not, of course, see any problems with our most recent ordinances.
Hold on just a second here. I've got one other thing before we move on. Subdivision regulations, we do have those in place. Those need to be incorporated into here.
Can we get that in our book?
I think so, I think it's this,
148?
it's in the.
I see it now, 148. Oh, yeah, I'm sorry, I did skip past that. What do you have in regulations there? Or what's been?
Oh, the
That is
new
on
water
the
ordinances?
Water side.
Yeah. And we also
Water
have the
regulations.
roadsides, like for the subdivision that was over here at Carroll Circle, requirements for them. We have those somewhere, 'cause I've read them. but I-
So my position on that would be,
I'm sure they were drafted by Steve,
Yeah, so.
so,
So we have some for the Carroll subdivision, we have the new ones that we just passed here a month or two ago on all the.
I can obviously see another, subdivision regulations morphing into the whole zoning,
Right.
component of this. And
The subdivision regulations for the water side of it though, address more of the water hookup side of it, not for the building,
that's right.
Right.
roads.
Yeah.
That's right.
And we only can regulate as far as building and roads, what's inside our city.
Right,
That's right.
So we can't,
but we do have something on paper, discussing what was required over in the Carroll subdivision.
I don't know if that fits, I don't know if you want to create a separate title, so to speak, for subdivision regulations though, because I don't know that you're going to have any more.
I would think that should go under the planning.
And that's what I'm thinking too, is that what we may do there is put that under the planning heading, if you will, and zoning, essentially, because it's gonna come to that.
Yeah.
So, you might want to, go back to that real quick. I think the best, maybe course of action procedurally there is to
Move the title 15 to title 13 under planning.
That's, that's as good as anything else. I think that's exactly where it probably belongs more than anything
And then if
else.
we find the subdivision documents that
Mhm.
state what was required, then we could put that in there. And
You can also just leave that, and what you can do is we could adopt a really quick, ordinance number 15, or whatever the number is, the suggested number there, 15.0, whatever. And we could say that, again, without getting into a specific agreement that the city has reached with any specific developer or property owner or whatever, I think what we do there is we say that subdivision regulations and restrictions or whatever may be adopted from time to time by the city council. Problem you run into there is now though is,
Would have been years ago.
well, and you got you maybe put a cart too far before a horse, because I don't want to have to then go back and repeal a subdivision ordinance when a zoning ordinance covers it.
That's true.
So,
But the only difference I see in maybe the zoning would be the requirements for like roads and sidewalks
Yeah,
and all
yeah.
that stuff.
well, and you know, lot size, things like
Right.
that you want to have governance over when it comes to
Right.
that. Right now, I agree that maybe the thing to do is just take that statute and or ordinance and slide that into the 13 spot under planning. I do think that makes more sense than setting aside now that we have 13 set aside, let's use it, call it. And honestly, there's a part of me that would just like to call this planning and zoning
Yeah.
as a single
One.
chapter.
Yeah, I agree.
So let's do that if y'all have no concerns with that, because I think those two go hand in hand in just about everything.
14 and 15 to 13.
Correct. And again, since that's just basically the municipal league's numbering of this, we don't really have to make any substantive changes there. Like I said,
No.
I think that the thing to do is to just, again, on some of these where it's the municipal league's draft, so to speak, and they've got these headings and stuff, you guys don't have to do some enactment of an ordinance on that front, you know what I mean? Get it collated and all these little things cleaned up, and then, of course, that'll just be,
Set the document.
yeah, exactly.
And once we get these submitted to them, then they're gonna send us back
A
a
clean-
clean manual.
that's right.
Clean manual.
Yeah,
And then that's what we're looking for.
Yeah.
That's what we haven't had in the past, and we need to have it, and everybody, all the council members will have their own book, so they'll have it in front of them. We'll have it all together and organized finally.
I will try my best to get you all, my changes and drafts, if you will, by next Friday, which is the 10th. And so that will give y'all hopefully a little time to look it over before the 14th.
Okay.
In the meantime, y'all obviously text, email, call me questions or anything like that. If something else y'all see later strikes you, let's talk about it. But, I can't say enough about the municipal league doing something like this. It made it easier to do this. The reason we couldn't have this sit down is because it was just too unwieldy, and now that you can do this, this is the kind of session that we can have every year, and I think it's a really big benefit for towns like Damascus that don't have just a bunch of employees running around with nothing to do.
That's right.
I'm glad they did it.
Yep. I do too. It's real good service that they give to us.
And you guys all had great contributions and questions tonight. I mean, like I said, you're always going to be able to go through these things and say, we got some old stuff in here that we can jump. But, that ain't bad for us starting in 77. And here it is 25.
That's right.
I started in 77 myself, existing. And
born in 77.
You're a 77 model.
Yeah. I got a 30-year class reunion coming up next weekend too, so I'm feeling every bit of it. I know y'all are gonna say, "Oh, you're just a young pup," but trust me, I've heard you too.
I think you're old. I think you're old.
I know. Thank you. I appreciate it. I need somebody in the room to tell me that.
I don't think you're old.
Well, I appreciate it, Gilbert. But then again, you also think Nick Saban's gonna be our coach.
Hey, shoot for the moon, you might land in the stars.
Shoot for the moon and get the stars. I don't know if we're gonna get a star out of this.
We'll make a motion, we adjourn.
You got it. Motion made and seconded to adjourn. All in favor? We are adjourned. Thank you guys very much.